Let us pray. Lord, thank you for bringing us here another day to deal with your business, Lord. Please ensure that our deliberations are brief, to the point, and to your honor and glory. Thank you for the technical teams that continue to support this initiative and guide us, bless us, and protect us. These mercies I ask in Jesus' name. Amen.
Amen. Thank you. Let me apologize again for the late start. Are there any more apologies for absence or lateness?
Yes, there is an apology from the chairman, Minister Vaz, from member Tova Hamilton, member Aubin Hill, and Miss Keisha West from the Legal Reform Department, as well as Senator Shereen Golin Campbell has indicated that she'll be late. She should come on shortly.
Okay, thank you very much. Anybody else? That's it?
Chair, if I may, I do have to go to a 4 o'clock meeting, so unfortunately I'll have to be off at 3:55. But hopefully, Minister Green's prayer that we be short will actually play out.
Let us hope, because I don't want you to leave my side. You have nominated me, so I want you to be here with me.
Chairman, while you're at it, in terms of early departure, I had indicated to Mrs. Beckford that I wasn't able to stay beyond 3:30 today.
Yes,
not usual for me to stay the entire meeting, so I apologize ahead of time.
And I would want my friend to stay with me as well. I will see how fast we can go through the agenda item with a lot of stuff together. I want to welcome everyone to this meeting, and we know for a fact that persons are extremely busy, but this is very, very important. It will enhance the fabric of our country, Jamaica. So I want to thank you all for coming, and I understand for those persons who would have to leave, and Minister Vaz himself is unavoidably absent. So we'll just proceed. At the last meeting, if we can recall, the committee spent some time looking at matters arising from the minutes of the meetings held September 13 and 20, 2023 in relation to Section 53, in particular to the fines offenses of Section 28 of the Act and Sections 55 and 62, the definition of significant power outage, and the issues of rural electrification. During the discussion on the proposed fine of the offenses under Section 28, one of the recommendations from the ministry was for a fine of up to $7 million in respect to a body corporate for cutting the supply of the electricity from the transmission line. The LRD was asked to check whether the limits for the fine in the parish court went up to the $7 million. So that's matters arising that we would have to discuss shortly in terms of a report to this committee. In respect also to the significant power outage, the ministry indicated that they would address, the recommendation at today's meeting. The committee also discussed at length the proposal by the OUR for certain provisions in the OUR Act dealing with consumer protection and to be inserted into the Electricity Act to enable the OUR to carry out their consumer protection related activities effectively and with the required legislative support. The committee agreed to defer those recommendations to today's meeting to give members an opportunity to review them in further detail. Responses to questions were raised by Senator Golin Campbell on the issue of consumer protection, if we can recall, were submitted by the OUR, MSET, and also the Consumer Affairs Commission were circulated to members via email. Let me hope that everyone received it. I received mine. A submission on the issue was also received by the Jamaica Public Service and forwarded to the committee. So we have a lot to discuss in today's meeting. We hope that we will be precise and insightful in terms of these discussions, because taking into consideration those persons that must leave, and I'm sure these persons would like to add to the discussion as well. So that's my opening remarks for this meeting, and we will move hastily into reading, and we'll get back to some of the issues that we need to discuss in matters arising. So we will move hastily in terms of reading and confirmation of the minutes that was of the meeting that was held on September 13, 2023. Let me move that everyone received the minutes and looked over the minutes. Is it a fair assessment?
Yes, it is.
Just uploading my minutes. So let us move to page 1. Any correction to the minutes? Page 2. Page 3. Correction to the minutes, page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Moving on to page 10. Eleven. 12. 13. All right, since there is no correction to the minutes, is there a motion to accept the minutes as is?
I so move.
And I will second.
Seconded, awesome. All in favor?
Aye.
Those opposed? All right, it's carried. Matters arising from the minutes. We had some things that we wanted to discuss. I know member Golden Campbell had some issues in terms of follow, not necessarily issues, but follow. And also the 7 million was supposed to be investigated. The LRD was supposed to check as to whether the limits for fines in the parish court went up to 7 million. Was that done? In the interim, let me time respect for well organized minutes. and our team. If there wasn't any corrections to the minutes. Or can we get a report from LRD?
Mr. Chair,
Yes, sir.
are you hearing me?
Go ahead. Hearing you
I'm
loud
not
and
sure.
clear.
I'm not sure why the camera is not up because I've taken it off. But well, just in the interim, the concern was actually raised by Ms. Masada from the Aegis Chambers on the last occasion.
Yes.
And what I can say is that there is actually no official law that I could find that would say that the resident magistrate's court could not impose a fine greater than 5 million. However, it seems to be the practice, or maybe it's an unwritten rule, that the resident magistrate's court would not impose fines greater than 5 million. The most recent amendment done to the law was done actually in 2019, where 5 million was used. And I was able to also to find an amendment that was done to the Defense Act in 2014, where 5 million was used. And the current fine within the Electricity Act is 5 million. So I think we have been, certainly the government of Jamaica by policy, or certainly practice, has been using that as a limit for resident magistrates courts. That's what I can say there. And it's still correct that we'd not go above 5 million.
So why is that so though? Why wouldn't they go over the 5 million if it went up by 7 million?
Right, that has been the practice, to use 5 million for RM courts. I guess they want to keep the distinction between what would be the Supreme Court jurisdiction as opposed to the resident magistrates courts or parish court jurisdiction. So you need to keep that distinction between what is serious and not so serious.
Okay, members? Thanks, Mr. Simmons. Members?
So, based on that explanation, are we saying then that our adjustment, what the recommendation would have to be adjusted, or because there's no law saying that it can't, it would just be left to what's allowed in practice?
Mr. Simmons?
I'm sorry, you're kind of breaking up. I didn't hear the last part of the question.
I'm sorry. I was saying, based on what you have provided as the what is allowable, which based on the answer, there's nothing preventing $7 million. However, due to practice, what is this understood and accepted practice of 5 million? Would we change what we're proposing, or would we just leave it as is and then allow for the practice to take hold?
I would recommend that you keep the practice, unless there's really strong justification for moving it to 7 million.
Okay. I guess that's a decision to be made then by the ministry or the minister in terms of the policy direction, because the recommendation was made for 7 with some basis.
Recommendation.
Yeah, that's just a proposal.
Oh, right. Okay. Thank you.
So, Sir Simmons, you're recommending that it remains at the 5 million instead of the 7. Sir Simmons, any other members would like to?
No, I wanted to thank him for that clarification, because it was a point from last week, and I think it has implications for the way that the fines would be implemented. And so I really do think this is going to have to be a policy decision from the ministry to determine whether or not they feel that the $5 million maximum is dissuasive enough. And so but if it isn't, and they really want to go to 7 million, it has implications for how they would be implementing same. But so I'm glad to have that clarity.
All right.
Chair?
We'll leave it up. Go ahead. Go ahead.
Okay, I just want to confirm.
Ms. Hardo, we're not hearing it clearly.
Yes, what Mr. Simmons said, things as well.
We're having an issue here now. I'm not sure what's the issue.
breaking up? Am I
You're
not being heard
breaking up
of?
and you're breaking up and you're in and out. And there's a lot of statics.
Okay.
Is it? Okay, you'll type it. All right. Am I the only one hearing? Are you hearing her clearly?
No, I'm having a similar issue.
Okay. Great. I think she wanted to give an input. Let me just wait on the type. Anybody else would like to say anything that is concerned? In the policy direction, we'll wait on the ministry where that is concerned, but I'd like to hear what Ms. Sado has to say on the issue.
Mr. Chair, I saw a message come up in the chat from AG's Chambers.
Okay, I'm reading actually.
Good afternoon.
Yes, good afternoon. Evening.
Good afternoon, Chair, members. Just following up on the intervention by the chambers, I just wanted to remind the members that from time to time they may recall that there is a drafting technique where you can speak to penalties with respect to the jurisdiction of the court that is hearing the matter. So for example, you can have where the matter is brought before on summary jurisdiction, you have the prescribed quantum, and then you can provide that where the matter is brought on indictment, it's going to the Supreme Court. Then, of course, as the Chambers has indicated, that's a fine without limit. And then the judge presiding, when it comes to sentencing, then the court will be guided.
Definitely,
by
it's
the
a good
facts
point.
of the case. And
so what's your recommendation, Ms. Eden?
oh, this is purely a matter of policy. My intervention was just to indicate that there are various approaches.
Okay. All right. So we're guided by what was said, and I think it's a decision that the ministry would have to take, as stated earlier by Member Allen and others. And we will leave it to the ministry to make that jurisdiction know that we have the information at hand and what is out there. I understand that is the jurisdiction of the court. The minimum that a court will use is 5 million, but there's consideration that a court can use. So we'll leave that, if the committee so desire, that the ministry makes that decision in terms of policy directive. Agreed by everyone?
Agreed, Chair.
Awesome. All right. All right, so Member Golden Campbell, I know you had a concern at the last meeting. You want to bring us to that as well. We're still in matters arising, and let us move directly into that, since that's the agreement of the committee for the first issue. On the issue of consumer protection.
Yeah, sorry, Chair. I was just trying to bring it up. Well, based on what I have read from the response, there is, they do have the ability to take complaints in relation to these matters. I must admit that their response leads me to ask further questions. I was actually trying to bring up the response. For the indulgence a moment.
All right.
Yes, Chair. So they spoke about the process in terms of how a complaint about the utility services, particularly electricity in this case, would be dealt with. The question that arises for me from this is how many, I would love to know how many complaints they deal with, what really happens, because we may be having some duplications. And I just wonder how that is impacting the consumer.
Fair enough. Are they online? Could answer that question? Beckford?
Good afternoon.
Yes,
Shanae Riley from the OUR.
Yes, Ms. Riley, yes.
May I ask if Senator Golding Campbell could just repeat her question?
Member Golding Campbell, go ahead.
My question was based on the Consumer Protection Commission, Consumer Affairs Commission, sorry, indicating that they do deal with complaints about electricity service, and that once it's filed, the matter is referred to a complaint officer and investigated, and an appropriate redress sought. I would want to know further the particulars of that process. What's the typical timeline? What are the results that have been seen from that process?
Okay. So in our responses, we would have indicated that we have two types of activities, one in relation to appeals, which relates to submissions made to the OUR after a final decision has been made by JPS.
Hold on a second, please. Can I just intervene, Ms. Riley? Because I'm not talking about the OUR, I'm talking about the Consumer
Affairs Commission.
Yeah.
My apologies. So I will withdraw at this point.
Okay.
Beckford, maybe can assist us?
There's no
Consumer Affairs.
There's no representative online because I was not of the rule. I was not aware we were to invite them.
I think that's where Member Golding Campbell would like to address our concerns in terms of the Consumers Affairs. So is it fitting, Member Golding Campbell, that we invite him at the next meeting so your questions can be answered?
I would be grateful, Chair. And also, it seems as if there's no connection between the Consumer Affairs Commission and the OUR when a complaint is made to the Consumer Affairs Commission. Perhaps the OUR could speak to that.
Ms. Riley.
Thank you for that. I see we have members from our Consumer and Public Affairs Division online, and I would invite them to maybe explain to us how we collaborate with the Consumer Affairs Commission dealing with consumer complaints. Thanks, Yvonne. I see Yvonne is on.
Go ahead.
Unmute, Yvonne. Unmute.
My apologies. Good afternoon. Chair, we actually do have a memorandum of understanding where the CAC actually refers some cases, some complaints to us. So there's an established memorandum of understanding between ourselves and the CAC.
I'm so sorry, Chair. Could I ask for that to be repeated? For some reason, my connection dropped.
There's a memorandum of understanding between the OUR and the Consumer Affairs. But what I'm getting from you, Member Golding Campbell, is that you're not seeing this synergy where that is concerned. Could you unpack that some more, Ms. Nicholson? What's the memorandum of understanding entails, and what's the structure?
But from time to time, it is not a binding agreement. We do have several service level and other agreements with service providers as well. But when it comes to the CAC, if they do have complaints that they are not able to resolve, they do refer them to us and they follow through our complaints handling process here. Or if it is an appeal, it follows through our appeals process, which takes 65 days. Timeline is 65 days if it's an appeal.
So through you, Chair, it's a additional process or a synergistic process is what I'm trying to.
Yeah, it's a synergistic process, Senator.
Thank you.
All right. So what I'm seeing as well, that Ms. Beckford is a wish of the committee as well to invite Consumer Affairs at the next meeting, because member Golden Campbell has some questions that she would like to pose to them. So is that the wish of the committee? I know member Golden Campbell said yes earlier. But the other committee members?
Chair, I would welcome that. And I also had a comment on the response. I figure you'll go to the JPS response at some point, because I have a question at some point later. Thank you.
Member Allen, is that your desire as well?
I have no objection. It can't hurt.
Okay. So Ms. Beckford will ask the Consumer Affairs to be present at the next meeting so we can get some answers to some questions that we have as a committee. All right, any more matters arising from the minutes? I know Member Allen mentioned a short while ago about the JPS. You know, we have received a response from them.
Minister Dixon.
We sound alike,
yes,
apparently.
Absolutely. Member Dixon articulated our views a short while ago in terms of the response from JPS. You can go ahead, Member Dixon, and I'm sure the rep from JPS is here to answer your concerns. Go ahead.
Sure. And I'm actually asking about the question because they responded to a couple different two things. And I really wanted to talk about the first one, which links back to OUR and also Consumers Affairs Commission, which we were having a conversation about at the last meeting. In the response from JPS, they noted that they felt that putting in these provisions in the act would be a duplication of what is in the actual license agreement, and that the license agreement sets out particular terms that are pretty stringent, and they make the point that they have been paying in the event of their service standards not being met. So that was very much clearly outlined in the JPS letter, which was very interesting to me. And I wanted to hear from the OUR, and I also wanted to hear from the ministry what their take was on that notion that this would be duplicating and could create confusion and overlap, and also this argument in the letter from the JPS that says that if we do this, then there is going to be so much, the scope of OUR's operations would become so wide that that would be a concern. So I would love to hear the OUR's view on that, whether or not they see that the inclusion of those provisions in the legislation as they had proposed could be seen as redundant given what is in the license agreement. And then I'd love to hear also what the ministry thinks about that. Thank you.
All right, let us start with Ms. Riley.
Thank you very much. I have not had the benefit of reviewing in detail JPS's response. I will just indicate that this is maybe a preliminary response based on the question raised by Member Dixon. Certainly in terms of the inclusion of guaranteed standards or guaranteed standards scheme in the legislation, JPS is correct. We do have provisions in the license that address that. And in fact, we do have a mechanism where at tariff reviews, and we do have the power in between tariff reviews, we can actually, we meaning the OUR, examine the guaranteed standards and the compensation limits and make a determination as to what those standards should be and how it should be compensated. And our process is that we do, in fact, consult with those affected, which would be the JPS as well as its customers, before we make a determination in that regard. I think our recommendation, however, was coming from the perspective that the Act actually contemplated the possibility of multiple licensees. And so we thought it would be important to ensure that the implementation of that kind of a scheme was harmonized across all electricity licensees who may have standards obligations to customers. So it was in that regard, not as a replacement of the guaranteed standard schemes in JPS's license, but certainly to ensure that any licensee who would have that kind of obligation would also be subject to a guaranteed standard scheme. And we are mindful, for example, that the license tends to come out of a relationship, or it's a contractual agreement between the minister and the licensee. So we wanted to ensure that putting these kinds of requirements in a license will ensure, sorry, not in the license, but in the statute, it's harmonized in the event that there are multiple electricity licensees under the Act. So I think that would have been our primary concern there. And just to ensure that there's transparency, that there is an obligation on the OUR to consult with those who would be affected by any such scheme before we are empowered to implement it. So that could be also mandated in the legislation. So that was the context.
Okay.
And there is, in fact, instances in the Electricity Act where there is a grandfathering of provisions that may exist in licenses that pre-existed the Act. And so in the event that it is the policy of the ministry that it would retain the guaranteed standard schemes for JPS as established in its license, that could be expressly excluded or expressly grandfathered in the legislation in the event that those provisions are put in the Electricity Act.
Member Dixon, are you satisfied with that response from the OUR? Need further clarity?
I do note that it was said that that's the preliminary response because they've not had a chance to go through what JPS has put in, and I do understand that rationale that's been put forward, that this would be in the event of having multiple licensees, that you kind of just want to have those standards set out in the legislation, not necessarily relying on it, and also the possibility of what currently exists in relation to JPS being grandfathered in. I accept those points, but I would love, at least in the next meeting, I would like a reaction to the points that have been raised by the JPS when they have a chance to go through it in more detail.
We will do so.
Appreciate it. All right, let me hear from the ministry and now the same question that was posed by Member Dixon.
Good afternoon, Chair and members.
Afternoon, Ms. Campbell.
So we too have not had the opportunity to review the contents of the JPS's letter.
I'm sorry, Ms. Campbell, could you go a little louder, please?
Am I any clearer?
No, you're clear, just soft. You're clear.
Okay.
So if you could turn up your volume, that might be useful.
Better?
Yes, thank you.
Yes, go ahead.
Great. The ministry has not had the opportunity to do a deep review of the JPS's letter. So based on what Member Dixon has summarized, we would defer a full response, but to indicate that the JPS license is only the license. One of the objectives of the Electricity Act is the protection of consumers, and we believe that it is better for the regulatory framework to have even general standards or conditions or terms in relation to consumer protection. And the Electricity Act would be an appropriate tool to contain those provisions. And that would be our preliminary response at this time. And
I'm sorry, Ms. Campbell, please. I don't know if I'm the only one, but is there a background, someone else in the background that it might be interrupting you?
No.
Okay. Maybe is it Miss Riley? Her mic is open.
Somebody else.
I'm muted, Member Allen.
Sorry, I'm sorry.
Muted.
Ms. Campbell?
Yes. So, did you not hear something I mentioned, Member Allen?
No, I heard you, but you were beginning to be interrupted by a background noise that I'm no longer hearing at this time. So you may continue. I'm sorry.
Okay. So what I was explaining was that on the face of it, the Electricity Act seemed to be the appropriate tool to provide the general legal framework in relation to consumer protection. And consumer protection is one of the objectives under the Electricity Act. We also are of the view that the JPS's license is just one instrument, and that is also, it was also confirmed based on the negotiation of the parties. So the electricity license seemed to be the appropriate place to have the legal framework set out what the general standards are. But we will provide a full response when we have considered the JPS's letter.
Are we clear now, Member Golden Campbell, Allen, and Dixon?
Good. I'm looking forward to the responses from the in relation to the letter. So I'm good. Thank you. Thank you, Chair.
Okay. All right. Any more matters arising from the minutes? I think that was the main points that were lagging from the minutes that we wanted clarity on. Any more matters arising?
If I may, Chair, on the matter of significant power outage.
Yes.
We crave the indulgence of the committee further. We had sought to have consultation with the OER, and we thought it best to provide a considered opinion to the committee, but that did not materialize. So we are humbly seeking further time to conclude that.
Fair enough. So we have some stuff to obtain at the next meeting, and we'll give the ministry time to give us their intensive report on the issues at hand. Since there are no more matters arising from the minutes, we will have the continuation of the discussion on the Electricity Act of 2015, the matrix and the recommendation. Ms. Gamby, you're going to take us through that, or Ms. Bedford?
I will take you through, Chair.
Okay.
On the last occasion, we concluded with the discussion regarding consumer protection, number 7. We will now move to a recommendation at number 8, provided by the OUR. And the OUR has indicated that the provisions of the Act do not include provisions for formal dispute resolution process between industry players, including applicants for licenses by the regulator. It is therefore suggested that the following provisions be considered. 1, the office may resolve disputes between A, licensees, B, licensees and applicants for an electricity license, and in resolving such disputes, make such determination as it considers necessary to protect the interest of consumers and preserve the rights of a licensee. 2, any dispute as referenced in subsection 1 may be referred to the office for resolution by either party. The office shall publish the practice and procedures to be followed in connection with the resolution of disputes under this section. A determination made under subsection 1 shall be final and shall be enforceable as if it were a judgment of the appropriate court. Now, the ministry, having considered this recommendation, will indicate that the functions of the regulator to be that was proposed to be included in the Act at item 6 above included the power to resolve disputes between licensees, and in that respect, then we do not have an opposition to this proposal. However, we would wish for the OUR at item 4 that any decision that they make would not be final, and that there may be an appeal to the tribunal set up under this Act. We also would like the OUR to indicate a better rationale to the committee in relation to issues that they have had, which would justify their recommendation to the committee, and to indicate also whether their Act currently have dispute mechanism in relation to licensees. We know that some licenses would have the dispute resolution mechanism, but we would want to know if the OUR's Act currently has give them jurisdiction to resolve disputes among licensees and applicants. OUR.
With permission of the chair. So currently, thank you. Most of the licenses, electricity licenses in existence, don't have any provisions that address dispute resolution. There may be instances in maybe some of the PPAs that may allow for reference of matters to the OUR for determination where there are disputes. So there is not a consistency in treatment where disputes may arise. The OUR Act itself also doesn't have any provisions that deal specifically with disputes. And so where we are called upon to intervene, we will rely on, general powers that we may have to regulate the industry, to ensure that there's a proper functioning of the industry. So we will utilize, what powers we can pull on in that regard to intervene where disputes do arise. We also recognize that there is the possibility that disputes could arise with the single buyer in a pre-contract scenario. So, for example, where someone has been granted a license to provide particular services or offer a facility that would require interconnection with the single buyer, where it's in an instance of a power purchase agreement, or where it's the standard of a contract in the case of net billing, for example. If there is a dispute that arises even prior to a contract being signed and executed and brought into force, sometimes one or both of the parties may need the intervention of an intermediary, such as the regulator, to help them resolve issues that they cannot otherwise agree on. We do have these kinds of powers to settle pre- and post-contract disputes under the Telecommunications Act, and we do fall back on a lot of the powers that we have in that act, in that it's a lot more detailed in terms of how we operate in that sector. And so we would want similar provisions replicated in the Electricity Act, so that there is clarity where disputes do arise, so that the parties know for sure that they can come to the OUR to arbitrate. And we would also want some authority where we do make a determination on the matter, that it can be binding.
Okay, Ms. Campbell, you want to continue?
Sure, Chair. Having had that explanation, then subject to what we've said here in the matrix, we have no objection to the recommendation.
No, from the indication of everyone, I don't think there is any objection.
So then we will move on to item 9, another recommendation from the OUR, and this is in respect of electricity vehicle. I will read. The following are recommendations for the inclusion of a regulatory framework for electric vehicle penetration. The first one, in light of the definition of supply under the Electricity Act, there is the likelihood that participation in electric vehicles charging market will be restricted to the current electricity provider in Jamaica, who holds an exclusive license to, inter alia, supply electricity. It is suggested that the Electricity Act be amended to expressly include the activities of an EV charging station from being considered as a supply of electricity. Note that this change would also require related adjustments to the exclusivity provisions in the Electricity License 2016 issued to Jamaica Public Service Company Limited. Now, the EV policy approved and issued by the ministry supports charging as a service until there is a settled position on marketing framework post the 2016 electricity license. One of the chief goals of the EV policy is to ensure a dynamic and responsible national system for the development of efficient charging infrastructure in the island through a well-established legislative and institutional framework that covers the proper planification, installation, maintenance, and the establishment of minimum standards required to ensure its success.
Chair?
Yes, Member Dixon?
May I ask what that means? I'm sorry.
That's fine. I was about to ask the same question as well.
Yeah, because are you agreeing or are you not agreeing? I'm not sure. I mean, in terms of repeating what the EV policy says, I mean, are you agreeing with this? Because this is really a fundamental question.
Yeah.
So I'd love to know if the ministry could more expressly state what the position is.
Sure. And at this time, I'll invite CTB Richardson to address the committee.
Sir Richardson, the
Here,
man with
here,
the plan.
I'm not sure about that, but I'll do my best to try to explain to the committee. So with regards to the policy position of the ministry, we have a framework in place or policy position in place whereby we have been asked to ensure that we maintain the structure as we currently have it until an analysis can be done to look at the structure we currently have and outline to the cabinet what are the alternatives for the cabinet to choose an alternative market structure and regulatory structure. So given that policy directive, we are keeping the structure that we have, and the EV policy, which was promulgated in June, is putting forward having the same structure that we have currently, but we're offering electricity charging or EV charging as a service. This is similar to how the system has evolved, meaning that without the EV policy, we had third-party companies providing EV charging services to the nation. The JPS is one of those, and I think Evergrow is the other. And so it's an open market for someone who would want to provide it as a service.
Also, what are you recommending as a ministry for it to remain as is until you basically flesh out the EV landscape and give a recommendation to cabinet?
No, the EV landscape has been fleshed out. That policy outlines what we intend to do. And if I give a quick summary, it's to have a governing committee which looks at across the island and see where we need EV charging stations. There's a guide to say we should have at least one charging station per, I think it's 3 kilometer by 3 kilometer block of the island. So at least we have charging stations being developed across the island. And that would be open to any private entity who so wishes to take the power from the grid and provide it as a service to the consumer, so to speak.
So, Chair, can I ask a follow-up question?
Go ahead, sure.
Sure. The EV as a service, which is what was my understanding too. Isn't that counter to the OUR proposal? What I was asking was for you to be explicit in saying that
No.
yes, I am going down that road, or I do not recommend that we go down that road.
You're leading the witness?
A little bit, yes.
The recommendation certainly would be that we don't go down the road that recommended by the OUR. We let us get a defined position as to how we should move forward, have the cabinet approve that, and then we change a market structure or not as per the cabinet's instructions. And so in keeping with that policy directive, we would certainly decline the recommendation from the OUR.
Okay, what say the committee? I'm in line with that as well. You know, that's wisdom. As stated, it's a recommendation from the OUR. So we can either, as a committee, we can accept or reject for the time being. I think what Mr. Richardson stated from MSET, there's latitude, there's merit in what he has said. And I want to give the cabinet options for the cabinet to choose, and then we make a decision there. But what say the committee?
Chair, I join with you and I join with Senator Dixon. I agree that what has been put forward by the policy technical team from the ministry is the best approach.
Okay. All right, thank you, Member Green. Anybody else? right. Ms. Campbell? Ms. Campbell there?
I think she's muted, Chair.
My apologies.
She's unmuted now. That's fine. Okay.
The second recommendation from the OUR states, either in the Electricity Act or in discrete electricity vehicle legislation, provision should be made for the imposition of standards and regulation of interaction between participants in the charging market, including one, provision for the development of standards governing the accommodation of different EV types that may be imported into the country. Two, provision for the imposition of information requirements and technical safety standards to ensure reliability and integrity of the electricity grid, where charging stations are connected to the grid, and provisions for imposition of safeguards to avoid monopolization of the charging market, such as by the current exclusive supplier of electricity. Now, based on what Mr. Richardson said, the OUR's proposal in relation to the decision to be taken, then there will be a determination if there is a separate legislation or that provisions perhaps related to these would be included in the amendments to the Electricity Act. We would also wish to say that the EV policy currently outlines the minimum standards for importation, technical safety, access to charging station, and in relation to matters concerning grid connectivity, it is expected that these would be developed in the grid codes for electricity.
Are we okay with that recommendation, everyone?
I'm good. That's really similar to the other one, which says that there is already a policy and there's some matters in well, for this one, those issues are outlined in the policy. So I'm okay with the recommendation from the minister.
We were advised from Sir Richardson that there is an EV policy.
Yes.
Outlined the minimum standards.
Right, exactly.
Fair enough. Campbell?
Okay, let's proceed. Item 10 is from the Jamaica Chamber of Commerce. They have said, as it relates to electric vehicles, single buyers are not motivated. Legislation, including tax or tariff, needs to help to create the demand. Is there a conflict of the single buyer / distributor / seller to be the only entity to have the EV charging station? EV change to DC power, Act required 50, I believe is hertz. Is it the same, therefore? The Act needs to clarify of others. They can allow charging station, example, fuel stations. Well, we're not so sure how to interpret all of what has been said here. But we do state that there is currently one other entity that CTD Richard mentioned, other than the JPSO, that has charging station, and the EV policy is intended to outline matters related to the installation of charging station. In relation to tariffs mentioned there, the responsibilities that of the OUR, and regarding tax, the Ministry of Finance has responsibility.
Committee?
I accept what the ministry has said. Again, this is on EV policy, and I think they're basically saying that, you know, the tax related issues are the purview of Ministry of Finance, and tariffs are the purview of the OUR, and so these considerations wouldn't be in the act, and I can understand that recommendation. I don't really have an objection there.
So say all of us.
We move on to a recommendation from.
If I may, just for
Yes, Ms. Riley.
clarity. So in terms of tariffing, so we would regulate JPS's tariffs. So if EV charging is deemed a service separate from supply of electricity, the OUR would not be involved in regulating those tariffs. I hope I've not misunderstood the ministry's policy. So if, for example, the operator of the charging station is purchasing electricity from JPS, then certainly we would have a hand in determining those tariffs. But then what the person now sells charging services to the end user, the owner of the EV, I guess that would be outside of the scope of the OUR's responsibility, if that is not deemed supply of electricity.
I think Mr. Richardson had answered that question perfectly a short while ago. You know, I'd like to pose back that question to Mr. Richardson.
So Chair, with regards to what the OER just said, the individuals who put up their charging stations and put them towards the public, they are going into a market environment. So it becomes almost like a retail station selling gasoline. They will have to adjust their prices to ensure that they can entice the customers to use their charging points. So I would think the market will determine the ultimate end sale rate to the consumer.
But there are the regulations without a shadow of a doubt, you know. But I think as soon as, you know, the recommendation is made to cabinet and all that will be ironed out.
Right.
Ms. Riley, satisfied?
No, I just wanted. The intent was simply to clarify the comment, or in terms of the OUR's responsibility for tariff. And my presumption is that is the tariff payable for charging services as opposed to electricity. The response from the ministry simply said the OUR is responsible for tariff. So we are responsible for tariffs for the sale and supply of electricity. So I just wanted to make that distinction clear.
Definitely. All right. Ms. Campbell?
We move to number 11. The JPS is proposing to limit the impact of the inherent network cross-subsidy of grid customers to distributed energy resources customers. It is proposed that the GOJ should not consider a further increase in the capacity allocation cap to the program. The GOJ should, however, consider changes to the regulatory tariff regime for the distributed energy resources customers to contribute more to grid cost recovery. In consultation with the OUR, the following is provided. Cross-subsidization is the payment in part or full of the cost incurred by one class of customers by another set of customers. This is sometimes allowed based on government policy to deal with energy poverty or to incentivize the use of new technology. The appropriate way to deal with cross-subsidization, when it is deemed to be undesirable, is to have cost-reflective rates. The proposal for limiting capacity allocation for any group to deal with cross-subsidization is a suboptimal approach. The issue is rooted in the approach towards cost allocation. The issue of capacity allocation to DER should be appropriately kept outside of the legislation, since cost allocation and cost reflectivity are already addressed in JPS's license. Further, the changes in technology now taking place in DER and other technologies impacting the sector could render capacity allocation short-sighted.
I think I'm good with that as well. Committee members?
On this one, Chair, I'm going to defer to the ministry and the ministry's opinion, because we have JPS, we have OUR opining on it, and OUR stating that they believe it should be kept out. And I think it's a pretty reasoned argument. I just wanted to know if the ministry, well, I guess if you put it in that column, it's your recommendation too, correct, ministry?
Correct.
Yeah, so I think I can go with that. I can live with that one. I have no objection, Chair.
Awesome. Anybody else?
No, I agree with the position put forward by the ministry and the OUR. Reasonable.
Thank you. In relation to item 12, the JPS is recommending the inclusion of a new provision on grid defection and standby charges. In an effort to curtail grid defection, we propose the inclusion of a provision that requires any person or entity defecting but remaining connected to the grid to pay a standby fee reflective of the cost of infrastructure required to bring them electricity when needed. In our consultation with the OUR, we present the following to the committee. Grid defection is a problem that has its origin primarily in high electricity rates. The solution is not to put barriers that are intended to deter migration from the grid. Instead, the focus should be on putting electricity prices on a downward trajectory. Moreover, customers, whether standby customers or otherwise, should be required to pay rates that reflect the costs they incur in assessing such services, except where policy directs otherwise. That should be the fundamental principle on which costs and rates are assigned. And this is already captured in the JPS license. Hence, this specific proposal for the legislation is unwarranted.
I'm just seeing where Member Green wants to come in on this matter. So I'll give him the opportunity to do so.
I'm not sure where you saw that, Chair. But since given the opportunity,
You're an MP of a constituency. You
I
know the cry out there.
I strongly join with the points raised by the OUR. I think this would provide a level of protection to the JPS that would be injurious to people who are, taking matters into their own hands to try and craft a better solution in relation to the cost of electricity. I think the focus should be on driving down the cost of electricity.
Absolutely.
That should be what the JPS should be focused on, so that people wouldn't feel the need to have to enter into their own sort of arrangements. So I would support the OUR's position. I don't believe that this should be countenanced, and I agree with the proposed way forward through the OUR and the ministry.
Member Golden Campbell. Or Member Dixon.
No, I'm with the recommendation as put here. The overarching goal is to get electricity prices down. And so I am in support of the OUR on this one.
And I'm in strong.
Sorry, Chair, I was trying
Go
to
ahead.
unmute. I concur with Senator Dixon Morris on this.
I'm in strong support of the OUR. And I think that's the intention of the committee moving forward.
Thank you. The recommendation from the Jamaica Institute of Engineers concerns the regulations made to the Electricity Act, and therefore could not be addressed in this review. And that's the same comment for number 15.
Okay.
On the matter of item 14 here, this was in the general matrix, and the same response is provided here. So we do not feel there is need to review this particular recommendation, as it was already dealt in the general matrix.
Yeah, fair enough.
That's the end of the general recommendations. Chair, members.
All right, guys, any questions? I think we have exhausted or questions in terms of the review matrix. Thank you, Ms. Campbell, for bringing us through the matrix. Are there any other business? Any other business committee members?
I have none, Chair.
Okay, and I know you just want to leave, so I think we're at good timing.
Thank you very much, Chair.
Today.
Absolutely. I have to let you pray every time I'm chairing a meeting.
I think so, and I think you need to do a similar prayer, Minister Green.
All right, since there is no other business, the dates of the next meeting will be Tuesday, November 9th, 2023 at 2 p.m. Can you just jot that down in your diaries?
Sorry, Chair, it's a Thursday, November 9th.
Thursday, my correction. Thank you very much, Member Bolin Campbell. Thursday, November 9th, 2023 at 2 p.m. That's the date of the next meeting. And of course, as we decided and discussed earlier, that Consumer Affairs will be at the next meeting as well, so we can get some answers to our issues that we have, and also a fulsome report from the ministry in terms of the response from JPS as well. All right, guys, thanks for accommodating me as your chairman for this meeting. And let me wish you all the best. Is there an adjournment to this meeting?
I definitely move.
Is it seconded?
So seconded.
Awesome. And all of us are in favor. Let me thank you again and have yourself a wonderful evening.
Thank you, Chair. You've done a fantastic job, and it's good to see all of you. See you at the next meeting.
Thank you,
Thanks for
Chair.
your
Thank you,
support.
everyone.
Sure.